Okay, good afternoon, everyone. My name is Peggy Wood. I'm an employment partner at the law firm of Chiesa, Shahini, and John Tomasi. And I'd like to welcome you to this Families First Coronavirus Response Act, What Employers Need to Know. So obviously there's a lot going on in the world. And first and foremost, I hope you're all healthy and safe. We will get through this. There's a lot going on. So I'm pleased to take this opportunity to educate employers and business folks about a major piece of legislation that was passed in the United States Senate and Congress. So I'm going to give you a brief timeline to let you know how we got here as far as this FFCRA Act. Basically, 2 weeks ago, Friday the 13th, President Trump declared a national emergency in light of the ongoing coronavirus pandemic. That day, the House of Representatives was very busy working on this act, which they passed on Saturday, March 14th at 1 in the morning. So a lot of moving parts. It was done in record speed. There were, and there continues to be, some ambiguities and gray areas, but those are being fleshed out as guidance trickles in. So the anticipation was that Monday, the Senate would be able to vote on that action. But there was a bit of a hiccup and a roadblock that came to the forefront on Monday, March 16th, when one of the Congress people who had voted against the act objected to it based upon technical irregularities that occurred in its hasty passage. Ultimately, though, the House got together, they unanimously approved a set of what was called technical corrections. But quite honestly, those technical corrections were quite substantive and also very beneficial to employers and made it a little more palatable and reasonable for employers to comply with this act. So it zoomed over towards the Senate on March 18th. It was passed on a bipartisan basis by a vote of 90-8, and it was signed by President Trump that same day on March 18th. Under the terms of the act, it's effective 15 days thereafter, which according to my calculations is April 2nd. But based upon guidance that has been trickling out in the last couple of days, it should be, well, I'm sorry, let me just back up. Based upon my calculations, the effective date should be April 2nd. The Department of Labor takes the position that is effective on April 1st. So I want to give you the two major portions that will apply to employers and which you need to familiarize yourself with. So again, it's effective, as I said, from April 1st. It has a sunset date of December 31st, 2020. So in the next 9 months, you'll have to comply with this act. The two significant employer mandates that we're going to discuss today are the Emergency Paid Leave Act of 2020, which I'll refer to as the Paid Sick Leave Act. Now that requires covered employers to provide up to 2 weeks of paid sick time to eligible employees who are unable to work or telework for various coronavirus-related reasons, which we'll discuss all of those aspects. And the second paid mandate that this law requires is what's called the Emergency Family Medical Leave Expansion Act. And that requires covered employers to provide up to 12 weeks of public health emergency leave to eligible employees for childcare reasons. So we're going to kind of flesh out what these two acts mean for employers. First of all, the act defines covered employers as private employers with fewer than 500 employees. So basically, if you're an employer and you have between 1 and 499 employees, you are covered by both these mandates. Now, that is a huge difference from typical FMLA leave. I mentioned this to a client with about 35 employees earlier this week, And she said, oh, no, 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 don't worry. I'm not covered by the FMLA. You're not covered if you're less than 50 employees by traditional FMLA, but this is emergency FMLA. And again, 1 through 499 employees, you need to know what this means. I had another client who was like, my goodness, why are the super mega employers with 500 or more employees exempt from having to deal with that, from this mandate? Well, that's a great question. And again, this was zoomed through Congress. So, you know, a lot of the details are unknown, but I've heard of 2 explanations for this limit. First of all, a lot of the very large employers have very good sick leave policies because they can afford it. But the more pertinent reason for this cap on the size of employers is that the act, as we'll discuss later, provides for tax credits. And Congress did not want to give those tax credits to the huge employers. So we'll discuss the tax credits that will subsidize these payments under these 2 mandates. Okay, so the second question is, who's an eligible employee under each of these acts? Under traditional FMLA leave, an eligible employee is one who has been working for the company for at least 12 months and has worked at least 1,250 hours in that past 12 months. Those requirements are out the window with these 2 laws. Under the Paid Sick Leave Act, there is no durational requirement. So if you started your job on March 12th, you know, before that Friday the 13th, you would be eligible for the paid sick leave benefits. As far as the emergency family medical leave benefits, that applies to all employees who have worked for the employer for at least 30 days. So I want to flesh out some of the details under the Paid Sick Time or the Paid Sick Leave Act. And that an employee can receive this benefit for the 6 reasons that are set forth on this screen. If an employee is unable to work or telework, and by the way, the addition of telework was an amendment in those technical corrections that were made on March 16th. And you'll see that there's 6 reasons and the colors are different. I made the different colors because what you need to pay them depends upon what category they're in. So the top 3, you get higher benefits. The bottom 3, lower benefits. So we'll just go through them. And employees are eligible to receive paid sick time if 1, they are subject to a federal, state, or local quarantine or isolation order related to COVID-19. By the way, the act does not define local quarantine or isolation order, but presumably if you are told to stay home and you are a non-essential employee, most likely you would be eligible for leave under that portion. Section 2 is if an employee's healthcare provider says stay at home, self-quarantine because of COVID-19 concerns. Or 3, they are experiencing symptoms of COVID and seeking a medical diagnosis. So that number 3, you need to flesh out both. So if you're having a fever, a sore throat, a cough, and you're attempting to seek a medical diagnosis, then you would be eligible for this leave. Number 4, again, 4, 5, and 6 are subject to lower reimbursements, but if you're caring for an individual who's either subject to a quarantine order or is self-quarantining, you'd be eligible for PST. Or 5, you are caring for a son or daughter because of their child's school or usual childcare provider is unavailable due to the COVID pandemic. And that one is bolded and italicized because that is the one basis for which employees are also eligible for Emergency Family Medical Leave Act. So that's an important one. I want you to take note of number 5. And number 6, they are experiencing substantially similar conditions as those specified by the Secretary of Health and Human Services. I still don't know what that means. That really hasn't been defined. So number 6 is sort of a catch-all, and we'll see if that has any meaning in the coming weeks. As with all of this stuff, every single day, almost hour by hour, there's new information on the federal and state level. So a lot of moving parts, but this is what we know as of now. So those are the 6 reasons for which an employee can obtain paid sick time. The question is, how much paid sick time are employees entitled to? Schools in New Jersey are closed at least until April 17th, possibly through the end of the year. People might be in quarantine for God knows how long. But under the FFCRA's Emergency Paid Sick Time Act, there is a limit. It's essentially 2 weeks. For full-time employees, you get 80 hours of paid sick leave. For part-time employees, you're going to get the average number of hours that the employee has worked over a 2-week period. So essentially, 2 weeks is the cap of paid sick time under the FFCRA. Now, how is paid sick time calculated? That's why I have the separate colors on the slide a few pages ago. If it's basically for your own quarantine or to take care of yourself, that employee will be paid at either their regular rate or the applicable minimum wage, whichever is greater, up to $511 per day and $5,110 in the aggregate. So again, that's over a 2-week period. If it's for reasons number 4, which is you're caring for somebody who is subject to a quarantine order or is self-quarantining, or 6, that sort of catch-all provision that doesn't seem to have a lot of detail, then you're entitled to 2/3 of your regular rate of pay or 2/3 of the applicable minimum wage, whichever is greater, up to a limit of $200 per day and $2,000 in the aggregate over that 2-week period. So for leave reason 5, that is the reason where you're caring for a child because your child's school is closed or their daycare provider is closed. Then you can also take 10 weeks of expanded medical, FMLA leave. So for folks in that category whose kids are home and are trying to become homeschoolers at this point, those employees shall be paid at 2/3 their regular rate or 2/3 the applicable minimum wage, up to $200 per day. So it would be $2,000 for the paid sick time. And then they also get 10 weeks of paid expanded family and medical leave. So arguably over 12 weeks, folks with children to take care of could get the total of $12,000 over a period of 12 weeks. When can an employee use paid sick time under the Families First Coronavirus Response Act? The Act states that this paid sick time must be available for, quote, immediate use by the employee, and that an employee may first use the paid sick leave under this law. The Act specifically prohibits employers from requiring an employee to use other paid leave provided by the employer before using this benefit. So an employer can't say to an employee, you know what, you have 2 weeks of vacation in your bank, you have to burn your vacation instead of this. The law prohibits that. So they get to use this benefit first. And quite honestly, because there's tax credits for leave under this, it helps the employer as well. The Act also specifically provides that any unused PST need not be paid out upon termination. So if everything's fine, you have no children to take care of, you're not subject to any order, but you decide to leave in September or October, it's not like you get a payout of this leave. It's either you need it or you don't, but you don't get it paid out. So in addition to the paid sick time benefits, the Act also has that expanded FMLA provision, the Emergency Family and Medical Leave Expansion Act. So that is a 12-week leave entitlement. Now, interestingly, in the first version of this bill that was passed that Saturday morning on March 14th, it included all 6 of the categories I discussed earlier. On those technical corrections that were made on Monday, March 16th, they dropped it down to 1. And the one reason why an employee would be able to utilize Emergency Family and Medical Leave Expansion Act leave is if that employee is unable to work or telework because they are caring for a son or daughter because their child's school or childcare provider has closed. So how does the emergency FMLA leave work? Like all sorts of FMLA leave, it is 12 weeks. Normally, your FMLA leave is 12 weeks unpaid. This is the first 2 weeks are unpaid. The law designates it as the first 10 days of an employee's EFMLA leave is unpaid. But then the remainder 10 weeks are paid. Again, the $200 per day and $10,000 in the aggregate account for leave under this. So if a person, they're fine, they're healthy, otherwise, then they have to deal with a child at home because of school shutdown. From April 1st through 3 months, April, May, June, so the end of June, they can use EFMLA leave. The first 2 weeks could be paid under the Paid Sick Time Act, and the last 10 weeks of that 12-week leave could be paid under the EFMLA. So that would be a total of $12,000 as a payment benefit for employees who are dealing with that issue. Similarly to the paid sick time, and employers cannot mandate that they burn their other leave. The question is, can employers mandate that employees use other leave instead of EFMLA leave? And the answer there is no. During EFMLA leave, while employees may elect to substitute any accrued vacation leave, personal leave, or sick benefits, employers may not require them to substitute their other paid benefits. So it's completely at the election of the affected employee. So then another very important question is, will covered employers be reimbursed? And the answer to that question is yes. You know, this is extraordinary legislation. This is the first time that that I can think of that the federal government is mandating Paid Family Medical Leave Act or paid sick time. And obviously employers are in a bind. The economy's, you know, doing terribly. There's a lot of uncertainty in the markets, and there's lots of federal money being infused. So part of this act, and part of the reason why mega employers are not subject to this act is because Congress or the federal government will reimburse employers for payments that they make under these 2 mandated leaves. Covered employers under the act qualify for dollar reimbursement through tax credits for all qualifying wages paid under this act, subject to the appropriate per diem and aggregate payment caps. As I set forth earlier, the tax credits go to the payroll caps that I discussed earlier. And I'm just going to take 1 minute to just go offline for 1 minute. Hold on. Okay, sorry about that. I had some interference in the background. I had to quiet down. So again, the tax credit reimbursements, and I would counsel you to speak to your accountant on this, but they're basically going to be payroll credits, payroll tax credits that you can take on a quarterly basis. to get the refund of the monies outlaid as a result of this act. Interestingly too, the applicable tax credits also extend to amounts paid or incurred to maintain health insurance coverage during the employee's time of leave. This is being fleshed out. This is not a Department of Labor thing. The Department of the Treasury is going to be instituting guidelines regarding the tax credit reimbursements under the Act. There's a few employer exceptions and employee exemptions that are included in the bill, and I want to address those briefly. So first of all, when your employee is on FMLA leave, typical FMLA leave is unpaid, but what it does, it gives them an absolute right to job restoration at the conclusion of that 12-week leave. There is a minor exemption in the Act for small employers with 25 or, sorry about that, for 25 or fewer employees. They do not need to reinstate an employee who has taken the EFMLA leave. If that reinstatement, well, first of all, if the position that the employee had when the leave commenced no longer exists due to economic conditions or other changes caused by the public health emergency. And quite honestly, that makes a lot of sense. There's a lot of jobs that are just going away right now. Hopefully they'll come back. But if at the end of the EFMLA leave, the job's no longer there, there's no need to reinstate that employee. In order to qualify for this exemption, the employer needs to make reasonable efforts to restore the employee to the position within 1 year after the date leave is needed. So there either has to be no more job, and there has to be some effort to restore the employee if things change, and hopefully they do. So another exemption that is certainly worth noting is a special rule for healthcare providers and emergency responders. So under the EFMLA, the employer of an employee who is a healthcare provider or emergency responder can elect to exclude that employee from leave. So basically, if you have, we'll just, we all, and thank goodness for our healthcare providers and emergency responders who are all working so hard. If you have, let's just say, an ER doctor who says, hey, guess what? I'll see you in 12 weeks. My kid's school has closed. And I need to stay home and care for them. That hospital can say, no, doctor, we need you. This is a crisis. The Act specifically includes that exemption. And they need not give the paid sick time or the paid sick time for childcare purposes, or the EFMLA, which is for childcare purposes as well, to healthcare providers and emergency responders. The Act also states that the United States Secretary of Labor is permitted to promulgate regulations excluding certain healthcare providers and emergency responders from the definition of eligible employee. And we are expecting those regulations out in the month of April. And also to exempt small businesses with less than 50 employees if compliance with payment of these payments would potentially jeopardize the viability of the business as a going concern. There's a lot of ambiguity in what I just said. Yesterday or Wednesday, I'm sort of losing track of days at this point, the Department of Labor issued guidance, and they said that, and the guidance in the form of frequently asked questions states that if you're a small employer, so less than 50 employees, and providing childcare related paid sick time and expanded family and medical leave would jeopardize the viability of your business as a going concern, then you should document why your business meets the criteria set forth by the department, and the department will address these criteria in more detail in forthcoming regulations. So Lord knows what's that going to be. One thing that the FAQs do say is don't send any materials to the Department of Labor when seeking a small business exemption for paid sick leave and expanded family and medical leave. So what does that mean? I guess just document if it's truly a cash crunch issue and you need to, you just don't have the liquidity to make these payments for employees who are not working. Document it and we'll see how this shakes out. But yeah, a lot of ambiguity in the law and hopefully some of these issues will be clarified in upcoming regulations, which the DOL has promised. How will this act be enforced? Like all of these federal employment related acts, employers can't retaliate. They can't discharge, discipline, or otherwise discriminate against any employee who takes paid sick leave under the FFCRA or emergency leave and or files a complaint or institutes a proceeding under or related to this act. The U.S. Department of Labor's Wage and Hour Division has the authority to investigate and enforce compliance with the act. But the Department of Labor, this is obviously legislation that has been rushed through. It is a lot to comprehend, especially at a time when there is a lot of change and uncertainty and a lot of emergencies and fires to put out. The Department of Labor has, in guidance and an enforcement memo, sort of acknowledged that, but to sort of, and so there is an enforcement memo that says the Wage and Hour Division is basically observing a temporary grace period of non-enforcement for 30 days after the enactment of the law. So President Trump signed it on March 18th. That would be until April 17th. So that would be amnesty for employers who unintentionally violated this act, but also acted reasonably and in good faith to comply with this act. But just to sort of show some of the confusion, there are two separate guidances from the federal government that give two separate dates. The Department of Labor's enforcement, the Wage and Hour Division's enforcement memo, said 30 days from enactment, which would be April 17th. And yet the Department of Labor's guidance on the website says 30 days from the effective date, which would be May 1st. So I would, of course, go, first of all, my advice would be to comply with it, get your ducks in a row before April 1st. Whether the amnesty period is April 17th or May 1, I don't know, because the federal government doesn't seem to know that answer, but I'm just gonna go with the shorter date. So another question that arises is how must employees be notified of these new leave benefits? So it was actually pushed out late Wednesday night, early Thursday morning. So just yesterday, the United States Department of Labor issued a model notice of the FFCRA requirements, just like a lot of posters you would have. And as with many other employment-related acts, the question is where, must this be posted? And yes, it must be posted in a conspicuous place on the employer's premises. Of course, I haven't set foot in my office in over a week, so I would not be able to see it, as would, I'd say, 98% of my colleagues. So of course, the FAQs that came out on the posting requirement note that an employer can satisfy this requirement by emailing or direct mailing this notice to employees or posting the notice on an employee internal or external website. So shoot your employees a copy of the notice. We'll be doing an alert, doing a hyperlink to this notice that will come out shortly. So mass email and intranet, whatever you need to do to notify your employees of this new law that comes into effect on April 1st. I just want to touch briefly on the interplay of other employee benefits for New Jersey employees. the FFCRA specifically states that it does not diminish the rights or benefits that an employee is entitled to under any other federal, state, or local law, collective bargaining agreement, or existing employer policy. So under New Jersey law, eligible employees are entitled to earned sick leave. So you still need to comply with your earned sick leave obligations, which is an employer paid benefit. They're also eligible for New Jersey paid family leave benefits, and there were some expansions to that recently in a state legislation that was done actually remotely in light of the coronavirus pandemic and the social distancing requirements. And finally, you would need to comply with any benefits provided under your company policy. So with all that said, what should employers do now? You should be creating or updating your policies to include the 2 forms of leave that are available under this new law. Somebody asked me if they should update their employee handbook. I would say no, because you might not have your employee handbook re-updated on January 1st, 2021. So I think because this is this law sunsets on December 31st, and God willing, we have no need for this law after that time. I would almost just do a memo, and we're working on a template for this leave that could be pushed out to employees so that they're aware of it. Of course, distribute the required notice, as I mentioned earlier. Either post it in your typical spot if you're there. Otherwise, email it or post it on an employer intranet site. Also, I think this is important too, is make sure you're documenting the use of any leave under the Paid Sick Time Act or the Emergency FMLA Act so that you can obtain the tax credit. So, make sure that your internal procedures, whether it's through a HR software or whatever you do, make sure you're gonna get the credit for any payments that you make under this so that when you do your quarterly payroll tax, you can get the dollar for dollar tax credit that this law provides. And finally, keep up to date on new developments, including regulations and other new laws on the federal or state level. Easier said than done. When I tell you these things are changing daily, it's actually hourly, it seems. So I understand this is a difficult one. So, my firm does have a coronavirus task force where we're compiling all sorts of alerts on a multidisciplinary basis because this is having such a huge impact on contracts, on employment-related things, on tax issues. So we're trying to keep everyone updated on some of the major changes. So that is exactly 30 minutes, I think. So thank you for your attention. Timeout. I'm going to try to get to some of the questions that have been populating my
a lot of questions.
A lot of questions. Okay.
Yeah.
So,
do you want me to unmute everyone?
Sure. I think that might be better because.
Okay.
Yeah.
Because these things have generally been going a half hour. I feel like we should expand the time a little bit for these talks, just because, especially with the questions it'll go over. So.
Yeah.
Just so you know.
Ask a question. Kaylee, if you get a lot of background noise, I would say that it could be challenging unmuting everybody.
Yeah.
Yeah, I
doing?
agree. I think you should keep it unmuted, unmute
Okay.
everyone, and just read the questions off the chat.
Okay, sure.
Okay.
Well, hold on one moment. Come on.
Okay. So I'm gonna. And again, I'm.
There we go. You're good.
All right. Have they provided any guidance on what will be deemed self-employed? Is it not only non-W-2 Scheduled C or 1099 filers? That's a great question. This does, and I am focusing on employers, but this act does apply to the self-employed. The tax credit on that would be would be also reimbursable quarterly, but on your income taxes. So there is, you know, the Congress did recognize that, you know, the self-employed are being hit hard on this too. And so they do have that benefit.
So how do they get paid though? Like if you're struggling, like who's
I know.
paying?
That's a great question too. I don't know. It's almost like you're paying yourself, but you're getting a tax credit. So I don't really know. And I haven't focused on the self-employed because I've been dealing more with the employers, dealing with the employees. So one thing I do want to note, and again, this is changing every day, hour by hour, is that there is a lot of aid on both the federal and the state level. The Senate is hearing that $2 trillion bill today. I'm pretty sure that's going to get passed quickly and signed quickly again. And again, I don't really know the details of that. But there is a lot of small business loans, some of which have complete, they'll forgive the loan if certain conditions are met. I don't want to get too far into the weeds because I haven't been following that too closely, but there's also EDA assistance. So look into, you have to kind of look into everything you can. One question too is a great question. What about those that have recently terminated their employees and are down to just themselves? So that's a question I had, and it's not covered in the law, but what I did find to be helpful is the FAQs. And I'm telling you, I'm full of paper and FAQs and a couple hundred pages of legislation. So there is insight in the guidance as what about the folks, and this is sad, I'm an employment lawyer. In the last 2 weeks, I've just been on the phone with tons of employees doing layoffs, doing furloughs, cutting time, cutting hours. And certainly when you have an unemployment number of 3.2 million in the last, you know, reporting period, when the prior one was 200,000, so 3 million more. A lot of people have recently been terminated or furloughed. This law doesn't apply to those folks, so they cannot take advantage of this. There is certainly enhanced unemployment, and that's going through today in the $2 trillion relief package. But those employees, you don't have to pay those employees paid sick time or EFMLA leave. One of the questions, one of the FAQs that the DOL pushed out Thursday morning was, do I have to share this notice with recently laid off individuals? And the answer is no. The FFCRA requirements explained on this notice apply only to current employees. So those employees that employers have regrettably had to furlough, you know, those restaurant workers, those retail workers, they don't have work to do. Those folks do not need the notice because they're not entitled to the benefits under this act. And again, there will be enhanced unemployment benefits. Okay. So let me just scroll down. One question is, what about those that have cut their hours and the hours of their employees? For example, a team of 5 all cut their hours to part-time so they can all get some income. Can they all apply for unemployment? Unemployment is, there is a partial unemployment in the state of New Jersey. And I think as long as the salary or the time worked is 20% or more. So yes, partial unemployment is possible in the state of New Jersey. And, you know, the New Jersey Department of Labor is being slammed, but certainly you can apply. As far as the hours that are cut, that's a great question. So that goes to calculation of the hours permissible. And that is designated in some of these guidances, which again came out like a day or two. So we're still kind of learning them as we go. I think so. If you found yourself going from a full-time employee to a part-time employee, what the questions state is that you should use a 6-month average to calculate the average daily hours. So that might give them more leave than you would think. So if you went from 40 hours a week to 20 hours a week, and in a couple of weeks you need to take some of this leave, under the FAQs, you're gonna do a 6-month average if you've been there 6 months. If you haven't been there that long, you would do an average of the amount of time you've been there.
So would they still be eligible for the cost sharing plan if they cut their employees down from full-time to part-time?
If they cut, what are you talking about, the cost sharing plan?
I thought there was some sort of legislation in place in this package that said basically if I can't afford to keep the employees all at full-time, but I move them down to part-time, there was some sort of like, or if I like borrowed in order to keep them full-time, that there was some sort of cost sharing packages or benefits that I could tap into.
That is not part of this act. That is part of the act that, like I said, the $2 trillion package. As far as the details on that, I don't know what it is. There are small business loans for people who do not terminate for a period of time, that they would get federal assistance and then a forgiveness of that loan. But that is not part of this act. So I can't really respond to that question in detail at this point.
Can you recommend, though, a resource? I think a lot of us who are small business owners feel really challenged and very much appreciate what you're doing here, but each of us have unique circumstances and we aren't big companies that, you know, can have large attorneys on staff. I mean, if there are people at your practice that are offering this for like a fixed fee that could help some of us navigate our own unique challenges, like, I just feel like I don't even know where to. I have 2 different businesses, 2 separately different sets of circumstances. I've been reading and researching online, but at the end of the day, you know, you don't know which thing takes precedence over the other. So if I take an SBA loan, do I knock myself out of a grant? If I take a grant, am I not eligible for this? Like,
yeah. No, you're absolutely right, and it's a lot to digest for small business owners, for medium business owners, for everyone. If you want to contact me offline, we can discuss, you know, some of those issues. I don't know specifically, you know, if there's, you know, like I said, everything's changing every day. So
yeah,
you know, feel free to reach out to me, and I could see if we could be some assistance.
thank you.
Yeah, one question said, we are located in New Jersey. Is this in addition to the 40-hour sick time? And yes, it would be. It would be, again, this is a little bit of ambiguity in this, but the way I read it, and when you look at the earned sick leave, this is a basis for earned sick leave, because they do say, you know, school shut down. The way I read the act, it's a little bit vague, but most practitioners share is that it's, you kind of stack the benefits. So for your earned sick leave, you would have to look at, do you front load your time? Are you accruing your time? So here we are in March. If you're using the accrual method on a calendar year basis, employees would have accrued 1 hour of paid sick time for every 30 hours worked. So however many that equals. So I would say that yes, you need to pay both under any of the reasons set forth, because it's either caring for a loved one, caring for your own health condition. So they would have benefits under both the earned sick leave and then the paid sick time and possibly the emergency FMLA.
What happens though to companies that just have to meet by these laws because they meet the size requirement, but they just don't have the cash flow to do that?
Well, I mean, in the last 2 weeks, I mean, cash flow is a huge issue. That's why you do need to, and again, I'm sorry I don't have this piece of the puzzle, because it is a puzzle, because it's not even enacted yet. There is massive infusion. So that's the big thing. But let me step back, because there is that small business exemption, 50 employees or more. If making these payments would jeopardize your continuing viability as a going concern, then as I mentioned earlier, you could be exempt. That is so vague, I don't even know how to start. All we have at this point is that the Secretary of Labor will be issuing regulations. So again, to elect that small business exemption, where you say, I can't do this because you're gonna put me out of business. It's a total cash flow issue. What the DOL has said in FAQ number 4 is you need to document why your business with fewer than 50 employees meets this criteria set forth by the department, which will be addressed in more detail in forthcoming regulations. That's not all that illuminating, but you could say, look, I can't comply. Guys, I can't, you can stay home, but I can't pay you because I don't have $200 per day. You could then, document it. And what does that mean? I don't know. Do you document your bank account? Again, there's a lot of ambiguity. We're trying to learn a lot in a very little bit of time. Normally, the whole legislative process has a lot of input, a lot of thought, a lot of debate, where we can glean legislative intent. This, like I said, went through in like 48 hours and required a lot of corrections because some of it didn't even make sense and some of it still doesn't make sense or some of it still isn't flushed out. But if you're less than 50 employees, document it, keep a record. I don't think the federal government's not looking to, pound people with this, but also be looking, like I said, at the state and federal benefits that are coming out each and every day. So let me see.
And I'm sorry to ask one more thing, because I think a lot of the same questions are for us that are small business owners. Once we do start letting these people go and we meet the exemptions where we only had a staff of 4 or 5, we've let them go,
Yeah.
and now we're down to just either 1 or 2. Are we as self-employed going to be eligible for unemployment? Are we going to be eligible for some of the benefits that we normally wouldn't have as self-employed?
Yes, you are.
Okay.
And honestly, when it comes down to that, because people sometimes ask me really big questions, detailed questions into the weeds, the best thing is to just apply, and the Department of Labor will make that determination. But the rules on that are certainly changing. So my advice would be to apply. And and by the way, the Department of Labor is just, every state Department of Labor is doing massive hiring to keep up with the demand. So you would be entitled to it under not this legislation, but legislation that's coming down the pike. Somebody asked a good question. What about leave taken before April 1st? Shouldn't that be regular NJ paid sick leave? Yes, it should be. So this comes into effect April 1st. And also, can employees choose to use PTO if they want to get their full pay instead of 2/3? I think the question to that is, I think they can use both. They can stack it. Employees have the right to demand to say, no, I'm using this leave benefit because, gray skies are going to clear up, and this summer they have a vacation planned. They don't need to burn it. It's at their option, which I mentioned earlier in the presentation, that they can utilize. It's at their option. They can use this or they can use that, their PTO. This is a question I think I answered. So furloughed or laid off employees are eligible for this. The answer to that is no. And that's from the guidance that was issued yesterday. Somebody states, if my company has furloughed an admin employee because she's unable to telework, can we try to give her some work to do periodically that she may be able to do from home and pay her hourly for that work? She is a non-exempt employee now. Yeah, absolutely. People have to be creative. People have to do what they need to do. Some employees cannot work as effectively or efficiently in a telework environment, but to the extent you want to rehire her, you certainly can. She would then have these leave rights at that point, though. Somebody, I can't even remember can this leave be used intermittently between April 1st and December 31st? That's a great question. Intermittent leave under the FMLA always gets somewhat confusing and administratively burdensome. But under the Emergency Family Medical Leave Act, there is no mention of intermittent leave. And most practitioners are taking the position that intermittent leave is not possible under this Emergency Act. It says, where can 1099 employees find information on their sick leaves? A lot of good information is on the United States Department of Labor's website to see what sort of benefits are entitled to the 1099 employees. Somebody said, how do we apply for the credits if we use a payroll service like ADP? Again, talk to your tax provider about how to get the payroll credit, and talk to ADP. I'm assuming, ADP is a huge provider, that they are making sections for federal paid sick time and federal emergency FMLA time. That's an assumption on my part, but speak to your payroll provider and certainly speak to your accountant on how to get those. So I'm trying to see, some of these are duplicative. Any other questions while I'm here? And I don't have much more time because I actually have a District of New Jersey appearance that I'll be making telephonically in the next 8 minutes. So any other questions? Since obviously all federal courts are closed, there was an outbreak of COVID in federal court. So certainly, and that's been shut down for the past 2 weeks as well. But
Peggy,
questions in the next 8 minutes? Yes, Alex.
Peggy, yes. Hi. This was really helpful. I'm an employment lawyer like you, and I've been attending a lot of these, and this one was I'd say one of the better ones that I've attended. So thank you.
Thank you, Alex.
Question. I know you said this. I just want to make sure I heard it right. Intermittent leave is not permitted under EFMLA? Is that clear?
It's not under EFMLA. It's nowhere in the Act. And I was actually speaking with other employment lawyers on this very topic yesterday, and we believe that it needs to be done. It's not available.
Yeah, I mean, would you agree that it should be?
No, I wouldn't, because
no,
if you think about the reasons, you're sick. I'm not going to be sick on Monday, but fine on Tuesday.
No, I was thinking more about for example, I have this situation where my associate is home with her 4 kids.
Right.
She's telecommuting, right? She's working at home, but she really can't work a full, now I know she's an associate, but she really can't work a full week. So I would like her to take, one sick, work a 4-day week instead of a 5-day week, basically, and use sick time. I mean, I know she can use her, paid sick leave, and if she wants to use vacation time, she can, but she wouldn't be able to use EFMLA for that? That doesn't seem right.
Well, we'll see if more regulations come out, but it's not provided for in the Act. So, I mean, you could do whatever you want, honestly, if you want to But as whether it's a mandate that you need to permit it, it's
Okay.
so.
But then would I get the tax, if it gets to that point where would I get the tax credit if it's just 1 day a week? That's
Yes, subject to the cap. So then, yeah, I mean,
it's only $200 a
1
week.
day a week.
Yeah.
Yeah, I mean,
if she's got multiple children, because I was thinking the same thing, like what if, God forbid, you have a child that's sick, you have to take 2 weeks of it, and then 3 weeks later your next child, God forbid, gets sick. It's a legitimate use case. It's just,
yeah, so you'd be expanding the 12 weeks over more than 12 weeks.
Correct. It would be over, right, 60
Then-
weeks, which
yeah.
God forbid we're going to be in this.
Well,
for that
60
one.
weeks is impossible because we're only through December 31st.
Oh, that's true. That's a good
In
point.
this act, we can, that's why I said if you should update your policies, but I don't think you should update your handbook because
Yeah,
January 1st comes, this is, in the garbage.
right.
So
That's true.
That's where we are.
So we don't know yet if the tax credit would apply for intermittent, for doing.
I think it would. I think it would.
So you're saying more, you don't have to provide it, but if you choose to,
Yes.
you could. Okay.
Yeah. And that's really the whole vibe of this. When I read the guidances, they don't, they're really trying to, be somewhat benevolent, obviously be benevolent in laying it out. One thing too, there is no certification requirement forth anywhere. Employees have to give notice as soon as practicable. So, it's a two-way street. Employer, look, I've got 4 kids at home. I can't do this anymore, or I just can't do this, or I'm sick, whatever. You could, especially for the sick leave, if I'm sick, you can ask for a doctor's note or even like an email from a doctor's office. Because just going back to paid sick time, one of the bases is they're experiencing symptoms of COVID and seeking a medical diagnosis. I think that's interesting. I'm having symptoms and I've been diagnosed. Because of the crush on healthcare, you don't even need a diagnosis. You just need to be actively trying. So calling your urgent care, calling your general practitioner. I need to get tested. They might not even have an appointment. So you might be able to ask for them to certify. I have been feeling, I have a fever, a cough, sore throat. I'm trying to go see Dr. Smith, can't get an appointment. The thought is that although there's nothing included in the act or the guidance we have so far, the thought is that they can certify. You can ask them for some information, that it's not out of the ordinary, so long as you're not asking for, very personal stuff, but it's sort of an overall certification. For those of you who have over 50 or more employees, you might often be using the federal forms to designate leave as FMLA. I'm not sure if they're going to issue another form, just like they did with the, for your own healthcare condition, for someone else's, for the various military-related leaves. All of that is in the works. So, we're keeping an eye on it. Keep an eye on my webpage because we are push out alerts.
I just wanted to let you know it's 1 o'clock, so I don't know if you have to jump on.
I do. Okay. So I hope.
Thank you.
And I hope you all stay safe and healthy and have a great weekend, everyone.
All right.
Thank you so much.
Thank you.
Bye, everybody.
Stay connected with the chamber. We have more seminars coming up.
Okay.
Okay, we'll do.